Ladies and gentlemen, gentlemen and ladies, ladies and gents, we have this so far away, and the song that's coming on after it is, a treasured favorite. But I want to talk to you all about the contract because a lot of you are misunderstanding the contract. A lot of you want help with the contract. You want to know who to send it to. Let me make sure you understand because it is really necessary that you stop contacting SATCOM and SAA asking them who do you send your contracts to. Do you understand that they cannot give you that advice? Because if you send it to somebody and let's just say it was the wrong place to send it or there were some repercussions or consequences, you could hold somebody responsible and accountable for it. Now, mind you, I would never let you hold either of the organizations I'm associated with accountable because they're providing that as a courtesy. But there would be some ignorant people out there thinking that they could. So, as a general rule, no advice is given on how to fill out any forms with the exception of the POA. Okay, that is as simple as it gets. It doesn't get any simpler than that. Some people are not going to be too happy with that as a response. Sorry, that's just the way it is. Can't change that. It's a fact. All right, hold on one second. I'll be right back. Okay, ladies and gentlemen, we're going to talk about the process from A to Z. We're going to keep this simple, sweet, and short. We're even going to talk about what happens after arbitration and what do you do during arbitration. Okay, everyone, I just had somebody today argue with me about the difference between a trust and a contract. And he was focusing on all by myself. Okay, he was focusing on the statutory provisions of a trust. I was focusing on the fact that man did not create a trust. Okay, it just ain't possible. Hold on one second. Okay, sorry, somebody was sending me some information on how to get in touch with someone. By next week, we'll be doing a video, and then I'll finish the conversation about the contract and the trust. By next week, we'll be doing a video. I told you guys about a particular phone that for 9 years, I paid $300 for. Ladies and gentlemen, I'm holding the phone that is on the 9-year account that I don't have to worry about any cell phone bills. It's on the T-Mobile and AT&T signal. So if you have a T-Mobile AT&T phone, the service will work for you. They're now offering it for 5 years for $300 or $400 or something like that. I don't know. It's called MCS Global, M as in Mary, C as in Charlie, S as in Sam, global.com. Go there if you'd like. However, SATCOM took the initiative because they said they were discontinuing the 9-year program, and we bought 5 extra SIM cards. All you need is a SIM card. You don't need anything else other than a SIM card and something that works with T-Mobile or AT&T's signal. Verizon and Sprint won't work at this time. Ladies and gentlemen, if you can get a T-Mobile or AT&T signal, you can use this service. I've used the service. I've had no problems. Drop calls. One guy they did a video and the guy said that he traveled the Grapevine, and the whole time he was on the Grapevine, he did not drop a call. Now, you must understand the Grapevine is just nothing but a bunch of mountains, and you're traveling through the mountains. There's probably one city, the entire maybe 9-10 mile stretch of going downhill. Okay, ladies and gentlemen, I was talking on the phone and I did not drop a signal. We were even able to conduct a SATCOM meeting while I was traveling with that cell phone, talking on that cell phone. So I'll give him his credit. But where there's absolutely no signal, you're not going to get a signal. Where there's absolutely no T-Mobile signal, you're not going to get a signal. It really is that simple. You need to have that 400 megahertz signal. We'll talk about this. We'll let you know that we're offering that 9-year for $400. So The 9-year plan, you don't get it with us. We're not offering the plan. The plan is already locked in place. The only thing it needs is activation. So if it is something you are interested in, we're going to be doing a video telling people we'll offer 2 plans. One is that they pay half, and then we'll give them installments on the rest of it so that they don't have to come out of their pocket for the full 400. Sorry, just after that stupid holiday where everybody spends all their money for no dumb reason. We know people don't have the funds. We did that because we wanted to help people. Okay, we're going to save one because we're going to literally choose a person at random who has picked a SAT pack, and we're going to give them that particular SIM card for free. Okay, we'll let you guys know when that is done and who the winner is. We'll just give you the last name. We'll give you just the first name, but we will not advertise the person's name and address and all of that stupid stuff. All right, let's get back to the contracts. Please do not write SATCOM about that. That is a program that I put together. So do not write them about that because they will not be able to give you any information. They will be instructed to tell you, I'm sorry, we have no information on that, blah, blah, blah. Okay? So don't do it. Okay? And some of you are told not to do something, you do it anyway. It's the Adam and Eve syndrome. You know, somebody tells you not to do something and you go ahead and do it anyway. It's called the Adam and Eve syndrome. If you haven't heard of it, it's been there since the beginning. So we know some of you are going to do it anyway, even though we say don't do it. So that's why I can tell you what's going to happen if it happens. Okay. And if you do it, you definitely won't be one of the ones that we will allow to acquire the SIM card. We said we'll do the video in the future. Not now. Okay. Let's get back to the contract. Ladies and gentlemen, the contract is simple. What we do is we send the contract off. After filling it out, the contract is universal. Each one of the contracts are universal. If it's for incarcerated people, all you got to do is change in the document, and we made it easier for you. We highlighted it, the he to the she. Just add an S or take away an S. Just as simple. Put your name where it needs to be. The Attorney General is still going to be the Attorney General, and then put your state. That's it. And then you send it for the incarcerated one. You send it to the DOJ. You can even send it to the warden. It's okay. You're not going to hurt anybody by doing that. But you send it to the Department of Justice for the United States, even if they're in state prison. And you send it to the DOJ for the state. Then you send it to if they're in state prison, the Supreme Court of the state, the presiding judge, because the presiding judge is usually the administrative officer for the entire court system for the state, under their administrative, the administrative office of their court, or the judicial council. Okay, and you can just pull up the address for the judicial council for your state and the Supreme Court for your state. Then you're going to send it to the legislature for your state. Okay? The contract specifically stated they have to respond to each and every agreement or proof of claim specifically and without a general response, with facts and conclusions of common law. This has nothing to do with statutes, ladies and gentlemen. So don't worry about what statutes say or what court case law says. The contract covers that. All right. Sorry, I've been answering a lot of questions regarding that, and people are not just trusting the process. They're trying to understand it. Well, if you want to understand it, that's a different program, a different process, and you're not going to get that from me because that's not my job to help you understand everything. Sorry, it's just the way it is. I don't have the time, don't have the energy, and I do not have the stamina for it. Matter of fact, things are getting worse, not better. So, my health is okay. I'm doing all right. Moving around, up and down, bouncing, rolling, hip hopping and robbing and dobbing and all of the other stuff. Okay, now that you have the contract filled out, you know who to send it to. You send it to all 3 branches of government, state and federal. Even if it's a state level case, you send it to all 3 branches federal, all 3 branches state. Just that simple. That's 6 different entities you send it to. If you are working with SAA will the fees are only for the first 5 mailings. Understand that. So that's just to make sure you understand, because documenting and mailing it out and copies and all of that stuff. Whoo, doggy, that's a lot of funds, and we ain't got ducats like that to be, and we got to keep the cost low, okay? And endless love. I love this song when it first came out, but they have overplayed this song to death. All right, let's get back to the parties. Now that you know who to send it out, plus you're going to send it out to the warden. What are you worried about? If it gets you or your loved one out of jail, send it to them. God, sorry, I got so many people talking about. Shut up. You guys are all whining about stuff, and somebody's doing you a favor, and then you want to whine, and then you want to act like, yo, don't stink. Okay? Like everything you do pushes out roses. Stop it, people. All right, now that you have all the parties to send it to, we're talking about incarcerated, so hold on. Now we're going to switch to the mortgages and the infant estate. The infant estate and the mortgages you send to all three branches of the federal government. Pay attention. And you send it to all three branches of the state government. Pay attention. Then you send it to your state treasurer and your federal treasurer. Not the Treasury Department. Pay attention to what I'm saying, people. To the treasurer and or their assigns. Just pay attention to the phrase. And or their assigns. Just that simple. Now, for the mortgages, you send it to the current mortgage company. If you were already foreclosed on, then you send it to the last known mortgage company and the original mortgage company. Now, those of all of you who even have current mortgages, you want to send it to the original mortgage company. The reason why is because that's where everything got started. That's how rumors get started. Started with the jealous people, and they got mad for something they had and someone else is holding. Sorry, Club Nouveau. Rumors. Now, you're also going to send a copy to the Department of Agriculture for both infant, and when I say infant estate, I am talking about getting control of the assets held in your minor account. People are talking about TDA. Ain't nobody and their grandmama said anything about TDA. Okay, you don't want the TDA account. That's a Treasury Direct. That's a limited account. Why would you want it just to have the limits? You want control over all of your assets. The contract covers all of your assets. Hold on, we're going to talk about why the contract works universally. So that's why you're sending it out to all of those agencies, okay? And you're just sending them a copy. Don't worry about a cover letter. The contract says everything it's supposed to say. Ladies and gentlemen, but what if they just respond, what is this y'all sending me? Ladies and gentlemen, if they respond, what is y'all sending me? Don't worry about it because your contract is specific. These are all competent adults. Oh, I'm sorry, did you not understand that the law requires them to be competent adults? And because they all hold a legal responsibility and you have a relationship with them, the contract becomes binding upon them because they are required to answer your redressable questions. You have the right to petition for redress. Your contract is construed as a petition for redress. You're telling them you need to correct these wrongs. Okay, you have the right to petition government, ladies and gentlemen, and that's what you're doing with each contract. That's all you need to you just need to understand that. You need to grasp that. Because with unilateral contracts, the law requires that there be a pre-existing relationship between the parties and that there be some sort of a bindingness in that relationship for one party to respond to the other. Well, especially if you're dealing with mortgages or if you're dealing with the infant estate. Look, that Social Security number is an account number. You all know this. Okay, that Social Security number can be used to pay bills. You all know this. We've been doing it. By the way, I have a guy who is still using the closed checking account method successfully. He's not doing anything different. The fact that it's working with some of you and not working with others, I can't tell you why, how, or anything. But I looked at his documents, and all he's doing is adding the same language that we're finding on the latest Our Style Money Order video that I put up there for you. Look, all I can tell you is that from day one, I've already known that it works. That's why I ain't got to sit up here and preach it to y'all. So I'm just giving you that information. Let's get back to the contract. Now we got all three contracts. They're filled out. The information is the appropriate information because they're all universal. All you have to do is add your personal information. Now look, if there's a situation that happened, if somebody tripped over the sidewalk and got injured, you don't have to add that. But if you want to, add it. But don't be adding a lot of junk, because if you say the wrong thing, you could kill your own contract. Well, I think it should say this and I think it should say that. Ladies and gentlemen, as long as you add a clause, one is already in the contract, okay? If any provision in this contract is deemed to be invalid, it does not affect and or preclude and or prevent the enforcement of any other provision of the contract. Something to that effect. Okay, then you can add your junk. Okay, but we are not responsible for your junk. We're not responsible for the template that's placed up there. You are utilizing that template because you are presumed to have gone over the information in that template. But there are misspelled words. That's okay. That's why there's a statement in there that says it is to be construed contextually, because we know some of you are not going to read it. So we protected you. Thank you. Thank you. Anyway, let's go on. Now we got the contracts filled out. What do we do with it? Well, we mail them. Who mails them? You mail them to each party. You do it not certified mail. Many of you want to do certified mail. I don't know where you're getting on that tip to send something certified. You don't have to send it certified. You don't need signature confirmation. You just need proof of delivery, because the law only requires that you notify the other party. Okay? Now let me make sure you understand. We have a situation where someone is claiming that they served proof of service on us at an address where there is no postal delivery. But you're sending it to government agencies, so you don't have to worry about this. But these individuals sent it to us to an address with no postal delivery. Not permitted in law. Not permitted in law. You see, that's not notice. That's not service. And so when we reminded the court, well, you guys didn't put in the proper motion. What do you mean we didn't put in the proper motion? You haven't read the motion, you stupid idiot. I'm sorry, I didn't say that to her because I wasn't on the call. But yeah, this is the stupidity that's going on. That's why we did the contract. And I can't tell you about the success we're having with the contract argument in court cases. I wish I could tell you, but it would affect a lot. But I will tell you shortly, so just be patient, because like I told you, I'm the test tube dummy. Oh, you're a dummy? Your mama. And we'll let you know as soon as we can. All right. Now that you got the contracts, now the contracts are filled out, now you've sent the contracts to all of the parties, okay? Every party has a copy of the contract. What do you do next? Ladies and gentlemen, you wait the days. You wait the 10 days. It's 10 calendar days. Once those 10 calendar days have been expended, then you send out the 3-day notice. What 3-day notice? The 3-day notice notifying them that they have 72 hours according to the contract to respond. There's a copy on the website. Okay? You don't have to add much. You just have to let them know, hey, the contract that you agreed to, you are now a party to the contract. After the 10th day, they're a party to the contract. You're now a party to the contract, and you haven't complied with the terms of the contract. Don't worry about the response part. You don't have to tell them they didn't respond. Just tell them they haven't complied with the terms of the contract, and that they have 3 days, 72 hours, to provide proof that they did not receive the original notification. Of course they can't, because you're going to send them copies of your proof of service, proof of sending it out through United States Postal Service delivery confirmation. Okay, that's all you want is delivery confirmation. How do you do delivery confirmation? Priority mail, because it comes with a tracking number. Okay, priority mail with the tracking number. That's all you need. You don't need a signature. Now, those of you who want to go for the signature thing, well, I need to have proof. You go right ahead. Okay, I can't even tell you how many ways that can go wrong, but you go right ahead and do that. You go right ahead and get your signature. That's right. You go ahead and don't listen to me. See, ladies and gentlemen, I can't tell you certain things on video because if I tell you, they'll figure out ways around this. Okay, there's only absolutely one way to prevent this, and they cannot. That's why I'm not going to tell it to nobody. Oh, they don't think like me, people. If they thought like me, they would have stopped it already. And that's why I told you guys it's necessary for you to get yours done so that you don't have to worry about that. You're grandfathered in. Look, all of those who got your stuff done and got it sent out, hey, welcome to the club. Okay? We'll worry about enforcement later, but right now we just need to make sure all of you guys are locked in and everybody and their grandmama know who you be. Say you, say me. Say you, say me. This one, like the Band-Aid song, Stuck on You, were some of my favorites by this idiot. I mean, by Lionel. All right, let's get. I'm listening to Lionel in the background if you guys can't hear it. I know some of the videos you'll be hearing me talk about the song and you can't hear it. It's because it's in my background. The music is for me, not for y'all. All right, ladies and gentlemen, now we got the contract. Now we sent it out to everybody. Okay, we wait our 10 days, then we send out our 3-day notice. Hey guys, you haven't responded. This is your opportunity. The only thing you need to do is provide proof that you have not received the document. By the way, you can't provide that proof because here's proof that it was sent out. Look, ladies and gentlemen, if they can provide proof that they definitely did not receive it, okay, that it was never delivered, then that's a lawsuit with the Postal Service because that means that they just provided false and misleading information on a public record saying that they delivered something. They are in violation of that contract. Too many problems are created that way. That's why you want to use the priority mail service. It does the same thing as certified. Just you don't have to worry about nobody looking at no green card on no document talking about the green card. What the? Okay, anyway, ladies and gentlemen, now that you've got your 3-day notice and you wait the full 72 hours, then that's it. You don't have to worry about that company no more. Don't have to worry about communicating with them anymore. It's not necessary because you now have power of attorney. The power of attorney says that they waive any and all services from that point forward. Some of you guys are not reading the documents, but we wrote it the way we did because we wanted to protect people. So now what do? Well, you notify them, you can do this. You notify them that they are in breach of the agreement and you're electing to seek arbitration. Now, do you have to do that? No. You can contact the arbitration association of your choice because it is your choice to choose the arbitrator of your choice because the contract allows you to do that because they have waived all rights. Okay? So you think you know the answer. Lionel Richie, everybody. All right. You choose the arbitrator. You let the arbitrator know, hey guys, I'll need your assistance. The arbitrator says, hey, this is what we charge. You say, I ain't got no problem with that. They say, okay, what's the address? Hey, fill out this application. Oh, and you have to fill out a notice of disposition. Now, ladies and gentlemen, with SAA, you have to fill out what's called a notice of disposition, request for disposition. So you have to request arbitrary disposition. In other words, for the arbitrator to determine whether or not there is a breach. You have to request that. We'll try to have that up on the site today. Okay? Say you, say me, say it forever, naturally. Uh, Ladies and gentlemen, now that you have that document filled out, the arbitrator will send a notice of hearing. And with SAA, they'll send a copy of your notice of request for disposition, which is your notification to them that you're seeking arbitration. They will object, shout, scream, holler, but they have no say so because the arbitration clause says you get to choose the arbitrator. And you will point that out to the arbitrator. See, this is that Band-Aid song, y'all. 1984, album of the year, Lionel Richie. The year the LA Raiders won the Super Bowl. Marcus Allen doing that nice little end and around touchdown. These years mean a lot to me, y'all. Been doing a lot of reflecting lately, especially listening to songs like this, thinking about my mommy and my daddy. And I didn't call him mommy and daddy. She was mama and he was Isaac. But thinking about my parents and thinking about the fact that they tried and the fact that they're not here and the fact that they've left no legacy. People think that their children become the legacy of their parents. No, the children do not become the legacy of their parents. Why? Because what do the children do? They go on and live their own lives. They become their own legacies. So what do we do? Death is final, or is it? See, here's the problem. Oh, I know my mama's up in heaven smiling down on me. She's smiling down on me. Anyway, ladies and gentlemen, if only you knew that that is from pagan beliefs, because they didn't have anything else to believe. They couldn't explain it, so they believed that people died and they lived on somehow because they couldn't believe that death was final. Because they couldn't be like animals because animals simply died. So they couldn't be like animals. So, okay, fine. So they conjured up this living on and being in heaven with God. See, I tell people if God wanted us in heaven, he would have created us in heaven. But what about the scriptures when they say people are going to be up in heaven ruling with God and his son Christ Jesus? Yes, but that was a separate group. And that was only after Jesus' death. So what about the billions of people who survived and lived, or excuse me, not survived, but lived prior to Jesus' birth? And the ones who lived after his birth? What about them? So, like with my parents, the scriptures, the Bible says that they have a hope of a resurrection, not in heaven, but on earth. Don't believe me? Go and look. Revelation, the 21st chapter. I ain't got to tell you what verse, 3 and 4. I ain't got to tell you what it say. It says that they will come to life. Go back and look at Revelation, the 20th chapter, where it says the rest of the dead did not come to life until 1,000 years had ended. And it all talks about the earth, doesn't talk about heaven. So I was nostalgia, thinking about my parents and the other parents who have died, and the many people who've lost their parents, and the many people who've lost their best friends, and their brothers, sisters, uncles, cousins, nieces, nephews, and so forth. And understanding the pain of each of those individuals. Not fully understanding, but understanding nonetheless. I am so sorry that people have to go through all of this stupidity on this planet. I am so sorry that people have to suffer. So I made it my life's work to help alleviate such suffering. I can't take it all away, and I can't help every person. I do understand that the needs of the many outweigh the needs of the one. Ever since I heard it said in Star Trek 2, The Wrath of Khan, by Mr. Spock, when he was coming out of the reactor, I have held on to that statement because it made a lot of sense. The needs of the many outweigh the needs of the one. So many people want one-on-one help. They want me to help them individually. Ladies and gentlemen, there is no way in the world that's going to happen. I'm not going to let you take my strength away. You can't even take my breath away. Sorry, ain't going to let it happen. Not going to happen. Not going to do it. Just wouldn't be prudent. The late George Bush. All right, let's get back to the contract. Just thought we would segue away from the contract for a second and then come back to it so that we can get rid of the people who don't really need to have this information and don't really need to be here. So what are we going to talk about now? Well, that's very simple, ladies and gentlemen. What we're going to talk about is, now that we got the arbitration, what type of arbitration do we seek? Well, we seek electronic arbitration. Why? Because with electronic arbitration, we ain't got to say nothing. We just need to provide proof that we notified them, they didn't respond. We give them the arbitration clause, which is part of the application for arbitration. And we show them in there where they agreed to the arbitration, where they agreed to this and they agreed to that. And that's it. And the fact that they did not fulfill their end of the agreement is the end of the conversation. Do you understand? No, you don't, but I'll do the best I can with trying to explain it to you. Because crack is a mighty powerful drug. Whew. Okay. Now the arbitrator has one choice only, to make a determination based on the contract and the arbitration clause and nothing else. See, the contract is specific that they cannot rely on statutory law. See, our arbitration has nothing to do with statutory law. Our arbitration is a common law document. It's an alternative administrative remedy. Okay, there's no such thing as a common law administrative remedy. Okay? Administrative remedy means they can regulate it because administrative. They control the word. Sorry, it's just the way it is. All right, so that being the case, once the arbitrator comes to a decision, the contract allows you to choose a court in any jurisdiction of your choice that has original jurisdiction to come to a consensus on the arbitration award. Now, some people are going to make their arbitration award for $1 billion, 1 quadrillion, 100 billion dollars. Please understand, the more unreasonable, pay attention to the word, the more unreasonable you make your arbitration award and the more unreasonable the arbitrator makes the arbitration award, the less likely it will be confirmed. Doesn't mean it invalidates the award. It means the less likely it will be confirmed by a judge. Then you'll have to go through appeal and all of that stupid stuff. So keep it reasonable, people. Treble damages 3 times the amount of the original claim is sufficient. It's cognizable by every court. Okay, plus attorney's fees and other fees. All right? If you keep it reasonable, those of you who do will get paid faster, will get yours faster. Okay, they have no defense on not responding. They can't say, well, Your Honor, we didn't understand what they were writing. Well, if you didn't understand, excuse me, what part didn't you understand? Really? You didn't understand that? Well, you had an opportunity to say that before the arbitrator. You had an opportunity to put that in writing. But did you not understand this right here where it said that you were in a cat's bird seat to understand this stuff? Okay. They like to change the subject. They like to play that game of ignorance and, oh, Your Honor, we just couldn't understand it. It was nonsensical. It was gibberish. It was gobbledygook. They like to use stupid words and stupid phrases and make it look like you're the stupid one. And many of you have been led to believe you are stupid. I didn't say this. You've said this to yourself. You said that you don't know this, you don't know that you're not smart enough to understand this, not smart enough to understand it. I didn't say that. I get too many emails from too many of you that are literally making it seem like you're the dumbest person in existence when you couldn't be that dumb because you found your way to this site. You found your way to these videos. And out of all those intelligent, smart people who have the opportunity of taking the time to listen, who can't handle music because they need to hear this. Come on, Lionel. My love. Okay, see, they can't handle that. That shows you their level of intelligence, and that shows you the level of my intelligence, because I do that intentionally to get rid of them. So you can't be too dumb. So once you understand it's your contract, you are in the driver's seat, you have control. The law says that with a unilateral contract and with the arbitration agreement, you have to stick to your guns. You cannot participate in a litigation. You have to let them know, I cannot participate in these proceedings until the arbitration is concluded. The contract does not allow. If you're in a criminal matter, let them know that, sorry, we have a contract here. This is an immunity agreement. I have an agreement with the state. Doesn't matter if it's criminal or civil. I have an agreement with the state that covers both criminal and civil. Go ahead and look at your laws under contract and see if it can't do that. That's how you handle these idiots. I had a judge say, well, I don't know if that can be heard in a criminal matter. And then the judge said, well, you haven't proven to the court that it can't be heard in excuse me? Proven to the court? You're supposed to know the law, idiot. I ain't got to prove nothing to you. I didn't say that because it wasn't necessary. The fact that they knew about the contract, that's all that was necessary, is for them to recognize the contract. And guess what? I mentioned the contract. I put the contract on record. Oh, that's right, ladies and gentlemen. Remember, you're placing it and filing your contract into the record. You can do it. Well, the unique thing that I do, I've helped with 4 different cases where I put the contract into the record. Pay attention. You're going to love this. I put the contract into the record during the case. It becomes part of the case. So, you know how they don't respond to your filings? When you put something into the record, they don't respond. The 10 days elapse without them responding to the contract. That's how I did them, because I'm tired of playing games with them. I am so sick of their stupidity. You want to say I'm this, you want to say I'm that? Well, you can call me anything, but don't call me broke, because you've just paid me. Thank you. Ladies and gentlemen, eventually the funds will come. Okay? My love. Come on, Lionel. Just thinking about you, baby. You see, he went country in a couple of songs. If you guys didn't pay attention to him, that's what he was doing. Pay attention. Okay, that's not R&B, people. This this is not R&B. This is country. This is his version of country. It's not the first time he did that in a song, and it worked for him. Okay? All right. Ladies and gentlemen, now we got to get to how do we get the arbitration confirmed? Many of you must understand this. The state and the judges are going to be reluctant to confirming your arbitration award. That's why you have to take and go into the court of least resistance. Now, there are several courts that you can go to. One of them that is of main precedent is the court of claims. But what I'm going to suggest you do is go to a court that is not in the jurisdiction of where the bank is or the main entity you're going after or going against. So if it's a federal issue, then you go into a state court. If it's a state issue, then you go into a federal court. And in each court, you highlight the fact that we have a contract and it is a binding agreement, binding up on both parties. And the judge is going to say, well, I will determine. No, you do not get to determine anything. This contract has an arbitration clause. And according to the law, only the arbitrator can determine the validity of a contract. Just that simple. This was a private agreement. This was not a public agreement. You have no jurisdiction over this contract. We didn't have to ask your permission to enter into this contract, and we don't have to ask for your permission to be here today respecting the arbitration award. We're here respecting the arbitration award, the arbitration award only. And you'll see that the arbitrator was reasonable and documented all of their findings. That's how you handle that, ladies and gentlemen. Many of you are going to want to argue. So you're going to have to read up on the Arbitration Act. But many of you are not reading up on the act. Many of you are just expecting for it to magically appear. Ladies and gentlemen, stop playing yourself for fools. Stop being fools. Read the Arbitration Act. Do your research. Become an expert. The more you know, the less they can do to challenge your contract. You must understand my level of confidence is because I didn't know much about arbitration before May of last year, because that's when I started going into it. And when I really started looking at arbitration was September. Okay, but I like where I am right now. I like where I am right now. Okay, ladies and gentlemen, that is once you get the confirmation award, once the courts confirm the award, then you go straight for writ of possession and enforcement of judgments. That's your baby right there. Writ of possession, enforcement of judgment. You get to start putting liens on things. Okay? That's where you're going. All right, ladies and gentlemen, we're going to run with the night. Playing in the shadows. Okay, I like this song, Running with the Night. Like I said, I can't stand him, but I like the song. Oh, you ain't to forgive him. It was 10, 20, 15 years ago that all that happened, ladies and gentlemen. I don't care how long ago it was. And actually, when I ran into him and went through all of that, that was in 1997. So, yeah, I think 21 years is enough, but he still gets on my nerves. All right. Thank you all for joining us. We have 40 minutes and 25 seconds, so we're going to let all of you get back to your lives. Goodbye, everyone.